Hello everyone, I'm Rosalind Pryor, speech-language pathologist and educational diagnostician, and I'm here today to talk to you about how Section 504 applies to students with attention deficit hyperactivity disorder or ADHD. So some of the information that I'm going to talk to you about today is about educational rights and children with ADHD. And I've talked to you about some of these in previous videos, but we're going to get into more detail about that today. So let's talk about, first of all, what is Section 504? So Section 504 is of the Rehabilitation Act, and it's a federal civil rights law that prohibits discrimination against people with disabilities. So it states that no individual can be discriminated against based on his or her disability. And it applies to all organizations, programs, or agencies that receive federal financial aid. So it's not just public schools. It applies to colleges and all federal aided programs. So the Office of Civil Rights, or OCR, enforces Section 504. And even though there is no funding for providing services required under Section 504, the OCR can withhold federal funds to any program or agency, for example, school districts that do not comply with the Section 504 regulations. So Section 504 provides individuals with disability protection against discrimination in school, preschool through post-secondary education, as well as in the workplace and other major life activities. Many of the same protections under Section 504 are also mandated under the Individuals with Disabilities Act, or IDEA. Section 504 also requires public school districts to provide a free and appropriate public education, or FAPE, to every qualified handicapped person residing within their jurisdiction. FAPE must be designed to meet the individual's needs and the needs of the child as adequately as the needs of the student without disabilities, and at no cost to the parents. I'm going to say that, and at no cost to the parents. Qualified students under Section 504 are entitled to reasonable accommodations, which generally means provisions of accommodations in the classroom, but may also include specialized instruction and related services. As with IDEA, Section 504 also requires placement in the least restrictive setting, or LRE, least restrictive environment. This means the child's education must be provided in the regular education classroom unless it is demonstrated that the education in the regular environment with the use of supplementary aids and services cannot be achieved satisfactorily. So the child has a right to a non-discriminatory evaluation by the school district, procedural due process, the opportunity to participate in extracurricular and non-academic activities, and a plan to support the student in general education. Now, how are students with ADHD found eligible under Section 504? It's a little different than under IDEA. Eligibility for Section 504 is based on the existence of an identified physical or mental condition or impairment that substantially limits a major life activity. Section 504 defines an individual with a disability as any person who, number one, has a physical or mental impairment, number two, has a record of, or number three, is regarded as having such an impairment. Section 504 eligibility is dependent upon the determination that the condition or impairment substantially limits a major life activity, such as walking, breathing, speaking, and or hearing, seeing, learning, performing manual tasks, and caring for oneself, activities of daily living. As learning is considered a major life activity, children diagnosed with ADHD are entitled to protection under Section 504 if the disability substantially limits their ability to learn. So students with ADHD who may not be eligible for services under IDEA because they do not meet eligibility criteria for special education are often able to receive support and intervention under Section 504. Now, students who do not qualify for special education services under IDEA are also automatically protected under the broader eligibility criteria of Section 504, but not vice versa. I'm going to say that again. Students who are qualified under IDEA are also automatically protected under the broader category of Section 504, but not vice versa. Section 504 students are not necessarily qualified under IDEA. Eligibility for Section 504 may occur when the child needs special education or related services. IDEA criteria requires that the student needs special education and related services. So children receiving 504 plans, not IEPs, are typically those who have less severe disabilities. Section 504 and IDEA have different criteria eligibility, procedures, safeguards, services available to the children. It's all different. Many children and teens with attention deficit disorder may fit the definition of handicapped depending upon the severity of their disorder. If the ADD or ADHD does not significantly affect or limit their learning or school functioning, they would not be considered eligible under Section 504. If their ADHD or ADD does significantly limit their learning or functioning, the child or adolescent would be eligible for reasonable accommodations and support. Now, this typically means developing a plan of appropriate interventions within the general education program designed to accommodate some of the students' special needs. The implementation of the plan is primarily the responsibility of the general education staff, not the special education staff. To determine the existence of the disability and the impact on learning, the school is required to do an assessment under Section 504. It is typically much less extensive than the assessment that is conducted for the IEP process and requires or involves the following. The IDEA process is much more extensive than the 504 process. So it requires the following: evaluation procedures that are non-discriminatory, generally a review of records, school and medical records, and various assessment data, standardized testing, evaluation of work samples, and behavioral rating scales are often used. Assessment tools that are validated for their stated purpose and accurately reflected the child's ability. Also, it's required that information from one or more tests or variety of sources are used in order to determine that the child does have a disability that adversely affects learning or educational performance. Often, the school's SST team is the same team responsible for the 504 evaluations. Usually, determination of eligibility and writing of the 504 plan. Now note, Section 504 contains fewer regulations than IDEA with regard to testing. It does not address the procedures, frequency, role of outside evaluations, or require parental consent for testing usually. Now, some school districts do want you to sign some type of consent to start the 504 process. That is fine. Parents seeking its service for their children may ask the school to consider whether or not their son or daughter may be eligible for any accommodations or supports under Section 504 if not under IDEA. If parents or the school suspects the child has ADHD that is adversely affecting the child's educational performance, which can include behavioral performance as well as academic, an evaluation needs to be done for the purposes of determining eligibility for services and supports under either IDEA or Section 504. Many schools have established procedures and protocols specifically for ADHD evaluations. Now, what is a 504 plan? A student found eligible under Section 504 must have a 504 plan designed to meet the child's educational needs. This is different from an IEP, an individual education plan, as it is much simpler and falls under the responsibility of general education and not special education. A 504 plan is intended to provide what is necessary for a child with disabilities to have equal access to education and opportunities to learn commensurate with that of his or her non-disabled or undisabled peers. A 504 plan generally lists and summarizes the reasonable and appropriate accommodations and interventions to be provided to the student or the child. These are the classroom interventions that the teacher is responsible for providing and can include the following, but not limited to: accommodations provided in other school settings such as the playground, the cafeteria, the school bus, program modifications, supplementary aids and services such as equipment, assisted technology, health, counseling, consultations. Even though it is often interpreted that a 504 plan means exclusively classroom accommodations, that is not the case according to the law. The school team must consider how to address all the students' educational needs. Now, what are the reasonable accommodations and modifications? And I'm going to say that again. What are the reasonable accommodations and modifications that can be provided under Section 504? Reasonable accommodations, supports, adaptations, and modifications are provided throughout the school system, throughout IDEA and throughout 504. But here's a brief summary of some of the more commonly used accommodations under Section 504. Environmental accommodations. They include providing a structured learning environment, preferential seating, reducing and minimizing distractions. They can be behavioral accommodations or modifications. Increased structure, supervision and monitoring, extra cueing and private assistance, support during transition times. It can be modifications or accommodations for testing and assessments, such as extended time, alternative times for test completion, modified format, administered in shorter sessions. Instructional accommodations. Break assignments into a series of smaller assignments. Use of highlighted text. Advanced organizers. Note-taking assistance. Peer tutoring. Tailoring assessments. It can also include organizational accommodations. Assistance with structuring of materials and their workspace and assignments. Help recording assignments. Establishment of home and school monitoring systems of class and homework assignments. Writing accommodations and supports. Use of graphic organizers. Teacher peer editing assistance. Permission to dictate while someone else records. Alternatives in written assignments such as oral or hands-on and demonstrations. Now, these are some points that you need to keep in mind though when talking about Section 504. A case manager is going to be assigned to monitor the child's progress under Section 504 plan. Though annual reviews are expected and typical In contrast to IEP regulations, 504 plans are not regulated as to the frequency of monitoring and review of the plan, although they are often monitored on an annual plan as well. Every school district is required to have a 504 coordinator who serves as the key contact person. Information regarding Section 504, eligibility, rights, procedural safeguards, and so on should be available upon request of the school district. You should be able to get those if you request those from the school district, usually the school counselor. There is also generally a designated person in the school responsible for 504 plans, and it's often, again, the school counselor. Parents can file a complaint with the Office of Civil Rights, as well as request an impartial due process hearing if they feel their rights are being violated under Section 504. Now, parents can file a request for due process hearing if they disagree with the school's proposed change of a child's placement, suspension in excess of 10 days, expulsion, interim placement. But unlike IDEA protections, now IDEA provides this child with a lot of protections that 504 does not. So unlike IDEA protections, the student is not granted the right to stay in the current placement while the hearing is pending. Classroom teachers need training in order to develop the skills necessary for teaching students with disabilities in inclusive settings. They need to understand the rationale and be willing and conscientious to make the necessary adaptations, modifications, and accommodations for their students with special needs, including children that are covered under Section 504. Now, school personnel need to be informed about the law and made aware that when students are on plans governed by legal mandates, such as IEPs and 504s, their compliance of what is written into the plan is not optional. It is not optional. They are required under the law to make those provisions and carry out the plan. If they refuse to do so, they are opening up themselves to the potential of personal liability. What happens usually is at the beginning of the school year, usually the 504 plans and the IEP accommodations are given to the teachers along with the IEPs of all the students that need special services or accommodations and modifications. That is what usually happens. Teachers usually keep those in a file of some sort, and they keep them where they can see them and review them and know what each student in their classroom is required to have. This is something that should be done for every student in the class that is under a mandated program like the IDEA or Section 504. It is not something that you have to ask to have done. It's something that should be automatically done in the school system. Now, you as a parent should have copies of these as well, and I encourage you to make sure that that is indeed what is going on in the classroom and that your child is getting the appropriate accommodations, especially if your child is failing or having difficulty in a class. You need to make sure that the accommodations that they are supposed to be having are indeed the accommodations that they are getting. If you have any comments, please put them in the comments box below. If you like this video, give it a thumbs up and please subscribe. Thank you and have a great day.